I am Lavanya Rajamani, Professor of International Environmental Law at the Oxford Law Faculty and a part of Oxford Sustainable Law Program. Welcome to what promises to be a fascinating session on the use of evidence in climate change litigation. We have an impressive lineup of speakers, Rupert Stewart-Smith, Fleur Ramsey, and Dennis von Berkel, and a hugely impactful recent publication to showcase. That's Oxford Sustainable Law Program's recent publication in Nature Climate Change and Filling the Evidentiary Gap in Climate Change Litigation. After we hear from the three panelists, we will have a brief opportunity for questions and answers. I would request that you please use the Ask a Question button at the bottom of your screen rather than use the chat function. This enables us to respond more effectively and quickly to your questions. It's not often that a piece of academic scholarship is both rigorous and speaks to the moment, as this one does. It speaks to the moment in several ways. So let me step back and offer a few context-setting words on the moment before I turn to our speakers for today. Climate change, it needs no saying, is the existential crisis and challenge of the century. How we respond to it will define us as a civilization and certainly as a generation. Yet after 3 decades of climate negotiations at the international level, we have an international climate change regime that has several significant gaps. These gaps are intentional. The politics did not allow for these gaps to be filled in the multilateral negotiation process. However, these are gaps that national, regional, and increasingly even international climate litigation is seeking to plug, albeit in a piecemeal fashion, and certainly climate change litigation or any litigation is not the answer or the whole answer. So what are these gaps in the international climate change regime that litigation is seeking to fill? First of all, the ambition gap, and the obvious ambition gap in the climate change regime. The centerpiece of the climate change regime, in particular the Paris Agreement, is a binding procedural obligation on states to submit nationally determined contributions. These nationally determined contributions, as the term suggests, are nationally determined, not multilaterally negotiated. There is no mechanism to review the adequacy of these national contributions, and there is no obligation of result attached to the content of these nationally determined contributions. So not surprisingly, this has led to contributions that do not add up to what is necessary to meet the goal identified in Article 2 of the Paris Agreement, which is a well below 2 degrees temperature increase. Current NDCs, including the updated NDCs, put us on track to 2.4 degrees centigrade. The second gap is an accountability gap. There is no mechanism to generate individual accountability for targets taken. Although states are required to provide information, they can choose the information requirements that apply to them. There is an enhanced transparency framework, but there is no robust review function in this enhanced transparency framework. There is a compliance committee, but it is facilitative and limited to ensuring compliance with a very short list of binding procedural obligations. The third gap is a fairness and equity gap. It's a central question in the climate negotiations and has been so right from the start, but the Paris Agreement sidesteps this issue because it's deeply contentious. And it sidesteps it by moving towards self-differentiation and national determination. There are a few remaining avenues for fairness and equity to be integrated into the climate change regime. The global stocktake is one of them, but how robust this is going to be remains to be seen. Climate litigation in national, regional, and international courts has picked up pace in the last 5 years, although of course it has been a tool that many have used over the years. And it has picked up pace in particular to address these 3 gaps, increasingly on human rights grounds. These 3 gaps in ambition, accountability, and fairness in relation to action by states, but also in relation to action by non-state actors like the judgment against Shell in the Dutch courts. The now famous Urgenda case, which Dennis spearheaded, was the first and most successful in addressing the adequacy and ambition gap in relation to the Netherlands, but it's by no means the last. The most recent one is the new Bauer case in the German Federal Constitutional Court, also spoke to the adequacy and ambition and even accountability gap. And the equity fairness gap is also being raised in national and regional climate litigation. In these courts, when claimants are arguing that national ambition is inadequate and needs to increase, the courts automatically ask against what concrete benchmarks is the national effort to be judged in the context of a collective action problem. What is each country's fair share? This is one of the central issues, even in the Portuguese children's case that is pending before the European Court of Human Rights. Many of the cases that are in the courts and have been in courts are likely to be unsuccessful for reasons that this paper discusses: procedural hurdles, legal doctrine in different jurisdictions. But where these procedural hurdles can be crossed, scientific evidence is crucial in reaching a successful outcome. Science is and has been influential in the international climate change regime, but it is not determinative in the international climate change regime, which is beset by politics and political dysfunction, but it can be determinative in litigation, and it is determinative in litigation. The IPCC, of course, produces an assessment of the science at regular intervals, and it has tremendous credibility, and litigants tend to rely on the IPCC for that reason, because it's produced, the latest report, for instance, is produced by over 700 authors representing 90 countries, 44% of them from developing countries. But the lengthy processes involved, the time frame for production of these reports, including multilateral negotiation of the final summary of policymakers, does mean that the most sort of up-to-date state-of-the-art science is not available to courts as they decide cases. This is the sort of point at which I would turn to our first speaker, who will introduce the Oxford Sustainable Law Programme's recent paper that focuses on the type of scientific evidence that courts rely on, one type of scientific evidence that courts rely on and need, that is the use and judicial interpretation of climate change attribution science evidence in climate-related lawsuits. Rupert Stewart Smith, who is the lead author of this paper, is going to briefly introduce the paper. He's a doctoral candidate at the Oxford Sustainable Law Programme and Environmental Change Institute, where his research focuses on climate litigation and attribution science. Rupert's recent research includes publications on the impact of climate change on glacial retreat in Peru, conducted in the context of an ongoing lawsuit, and the evidence needed to bring successful legal claims on the impacts of climate change. Rupert?
Lavanya, thank you very much for the introduction. Can you see my slides? Yes, okay. I trust you can see my slides. So I'm delighted to share with you this morning or this evening, depending on where you are, some of our recent research from the Sustainable Law Programme published just this Monday. And this research focused on the role of scientific evidence in establishing causation in climate-related lawsuits around the world. And just to step back briefly and reflect on the context which Lavanya introduced before, what has been collectively termed climate litigation encompasses a wide variety of types of legal claims, of which a subset of cases, often among the most high profile, have sought compensation for losses incurred due to climate change, or to challenge policies and increase ambition on mitigation and adaptation. And over the past few years, we've seen growing numbers of successful lawsuits, including recently in the Netherlands and Germany, Ireland and Belgium and others. And these cases have shown that successful climate litigation is possible. In those cases, courts ruled that countries or companies' climate targets or the implementation of those targets needed to be dramatically improved. So the power of the courts as a force for climate action really should no longer be in dispute. But despite those successes, climate lawsuits that rely on evidence linking greenhouse gas emissions to climate change impacts have not yet been successful on the whole. And many of those cases seek compensation from major greenhouse gas emitters for the costs of preventing climate change impacts or for losses already incurred by affected communities. Now, it's acknowledged that many of the outcome determinative obstacles to the success of those cases in the past did concern issues of legal procedure rather than the scientific evidence. But the question we wanted to answer in our research was, if we get past these initial obstacles, is the evidence provided by plaintiffs sufficient to establish causation? And if not, what can we do better going forward? And so to reflect briefly on the nature of the science itself, the science that can establish causation. So a subfield of climate science termed attribution science, evaluates the causal relationships between greenhouse gas emissions and their impacts, and asks the question, to what extent does climate change affect the likelihood or intensity of either individual extreme weather events or the magnitude of processes like glacial retreat or local sea level rise? And in recent studies, attribution scientists have also assessed how these physical hazards, those storms, those heat waves, the retreat of glaciers, translates into impacts affecting human societies, the impacts that might be the subject of lawsuits. And this scientific evidence assesses the causal relationships alleged in lawsuits on climate change impacts. And for some time now, lawyers have championed the crucial role that attribution science can play as evidence for causal claims in climate lawsuits. So how has this science been leveraged, and does it need to change going forward? Well, looking across 73 past climate-related lawsuits in 14 national jurisdictions, we considered cases in our analysis that based their claims on causal relationships between greenhouse gas emissions and losses incurred by plaintiffs. And there were two primary categories of cases considered by our analysis. Firstly, those brought against most commonly fossil fuel companies and other major emitters, seeking compensation for losses or the costs of measures to adapt to the impacts of climate change. And secondly, emission reduction cases. We only considered a subset of these because some of these cases were that had been successful were not really relevant to our analysis. But some of those cases which were brought mostly against governments, although in one recent case against companies, they seek injunctions for emission reductions and may make causal claims to meet admissibility requirements, specifically that greenhouse gas emissions from defendants will affect plaintiffs in some way, either now or in the future. And looking across these cases, we found that on the whole, the evidence submitted and referenced does lag considerably behind the state of the art in climate science. And importantly, this does undermine the success of some of these cases. Courts, on the whole, accepted that greenhouse gas emissions cause climate change, and in many cases, strong evidence was also provided on the prior knowledge of fossil fuel company defendants about the impacts of climate change that were likely to arise from their operations. But there were greater challenges in demonstrating the link between the emissions of individual defendant entities and the specific losses incurred by plaintiffs. In many cases, there was a focus on impacts for which the evidence may simply not be there that climate change has caused losses. For instance, some impacts of tropical cyclones and hurricanes have tenuous link to climate change, if at all. And in addition, in the majority of cases that we surveyed, attribution was often presumed to be there. It was presumed that impacts occurred as a result of climate change, and specific evidence linking these losses to the actions of defendants was not provided. So using the right scientific evidence could make successful litigation on climate change impacts feasible. And vitally, the above findings were not due to technical limitations preventing the development of required evidence. Rather, those tools exist. The question is whether or not they will be deployed in the courts in the future. And in addition to that key finding, we also considered what else can the scientific community do to bolster these cases. And in three brief recommendations, we point out that firstly, courts have found that plaintiffs failed to demonstrate whether the emissions of defendants contributed to present or future harms, and in some cases even incorrectly stated the impossibility of linking impacts to individual emitters of greenhouse gases. But science can demonstrate that that's not true, and if relevant, can demonstrate plaintiffs' marginal contributions to losses, or understanding how impacts would be different in the absence of defendants' emissions. Secondly, we can provide a more complete assessment of drivers of losses. In recent years, attribution scientists have become increasingly interested not only in the hazards driving losses, but in the wider issues of the vulnerability and exposure of plaintiffs to those hazards. And so we can now provide, or going forward, we may be able to provide a more complete understanding of why these climate-related losses occur. And crucially, we can identify the legally relevant causes of losses, and working in partnership with legal scholars and the legal community more broadly, we can understand how best we can analyze the drivers of losses, which could preempt defendants' arguments which seek to place responsibility for losses on the fact that plaintiffs, for instance, were vulnerable to impacts. If climate change is a game changer in driving those losses, vulnerability may not matter at all in a legal setting. And then we also ask slightly more technically, what kind of evidence really is most relevant for these lawsuits? When you conduct attribution studies, there are, for instance, a range of metrics that can be applied to evaluate the relationship between greenhouse gas emissions and the likelihood or intensity of extreme weather events. It seems that intensity-based metrics, those which show how the magnitude of a heat wave or a storm or some other event, may align better with the logic of the but-for test in law. But more research is needed and more collaboration between scientists and lawyers to understand more fully really which metric would best correspond to the arguments applied used in court. But overall, we want to know what we can do about it going forward. And the good news is that existing methodologies can provide the scientific tools needed to evaluate the causal links between plaintiffs' losses and defendants' emissions, and when the evidence is there, establish those causal links. Lawyers can answer the question, what are the key evidentiary questions that plaintiffs need to provide answers to? And do these causal links exist? Is it feasible to provide the relevant evidence? But that's the job of the scientists. Engagement between the scientific and legal communities allow research questions to be informed by the needs of the community of practice. The scientific community, with increased engagement with lawyers, can provide independent evidence to cases and substantiate those causal links that are at the core of climate-related legal claims. And scientists can also understand how best to align their research methods with the evidentiary requirements in legal settings. So rather than just providing evidence, also ensuring that evidence is useful for the legal settings. And if all this happens, then the implications for climate litigation really could be quite substantial. In future, effective use of scientific evidence could ensure that cases filed concern impacts that are, in fact, attributable to climate change, and that the evidence submitted to courts clearly substantiates the alleged causal relationships between defendants' emissions and the losses of plaintiffs. This would rebut incorrect claims that scientifically attributing impacts of climate change to individual emitters is infeasible, and it could overcome key obstacles to the success of litigation. Of course, it remains the case that further legal challenges still need addressing, but scientific evidence has a key role to play as well. And if that happens, it doesn't seem far-fetched anymore to suggest that future cases may force companies to pay compensation to communities impacted by climate change. But if that is going to be the case, and if evidentiary hurdles are to be overcome, and causation established in courts, the right scientific evidence needs to be in place. And we hope that the scientific community and the legal community will find clever ways of working together more closely in future to ensure that is possible. So thank you very much for joining us today, and I look forward to receiving your questions. But do please feel free to reach out by email with any further questions after the event. Thank you.
Thank you, Rupert, for providing us an overview of a truly impactful and sort of rigorous piece that is in Nature Climate Change, for those of you who want to look that up. The paper calls for creative, and as you do too, creative and clever ways for scientists and scholars to sort of interact with practitioners, and that's exactly what this panel intends to do. So we now have Fleur Ramsey, who is a proud Samoan and special counsel in the International Program and chair, First Nations and Indigenous Peoples Program at the Environmental Defenders Office, an Australian Pacific public interest environmental law organization. She is going to speak to the relationship between Indigenous peoples, legal claims, and climate science, touching on her experience of using climate science in Australian courts. She is an expert in Indigenous rights and international environmental law and an experienced litigator. She's currently overseeing the development of a First Nations and Indigenous-led program at the Environmental Defenders Office.
Thank you.
Fleur?
I'm just going to share my screen and let me know when you can see it.
We can't see it yet.
Sorry. Can you see it now?
Yes, we can.
Yeah.
Thank you.
Yeah. Thanks. I wanted to start off with a protocol that we use in Australia, which is an acknowledgement of the country that I'm on. So I'm on the Gadigal People's country of the Eora Nation in Sydney, Australia, and I pay my respects to their elders, past, present, and emerging, and I acknowledge that sovereignty was never ceded. I wanted to kind of talk, this is going to be a very different talk, but it does actually follow on from what Rupert was talking about in terms of how it is that we can work together as a community, particularly in relation to the claims that Indigenous people will be making in relation to climate impacts and how we attribute those climate impacts. But before I started, I just wanted to situate myself a little bit so you can understand where I'm coming from. And so basically, I am from the Samoan Islands and I'm from the western side, which is the independent side. The eastern side is still a colony of the United States, and Samoa gained its independence in 1962. It may seem small and it looks small, but Samoa in our ancient language refers to sacred center. And I can tell you that when I'm there, I do feel like I'm at the center of the universe and the center of the world. This is Oceania. And the reason why I'm showing you this is that I actually find that a lot of global north climate litigators don't really know the geography of this space. And we all know that Oceania and Pacifica, the Pacific Islands in particular, but also the Torres Strait, which is part of Australia, are at the front lines of climate impacts and also have been at the front lines of climate advocacy, particularly in relation to requesting that the world keep temperature rises to 1.5. And since the IPCC report, we now see the genius in 1.5 because of the catastrophic difference between 1.5 and 2 degrees. I work with the Environmental Defenders Office. We've recently merged. We were small state-based organisations which shared the same name, but we worked separately. We're now a national organisation. We've been chipping away for a long time, and one of our big successes was the Rocky Hill decision, which I won't talk about, but it really changed the climate litigation in Australia. And I think it paved the way for the Sharma decision, which was the recent decision which held that the Minister for Environment has a duty of care to children. We are very used to using science because we've had scientists as part of our organisation since 2003. And I can tell you that it actually makes a huge difference. It's a huge advantage to us to be able to pick up the phone and speak to a scientist about what strategies to use for our case. And they also hold a vast database of experts in this area as well. And it has made quite a difference to the type of cases that we've been running. And I am happy to say that one of our cases in the report that Rupert was referring to was considered to be one of the better cases in relation to the attribution science. I just wanted to quickly talk about a couple of cases that we are currently working on. Unfortunately, Papua New Guinea has vast coal fields, and that's all in the yellow there. And there is a campaign against the exploitation of coal in Papua New Guinea. There isn't an industry yet. Unfortunately, there's an Australian miner who's looking to develop one, and also the first coal-fired power plant in Papua New Guinea as well. So clearly the attribution science is going to be very important for us. But interestingly, Papua New Guinea has made the Paris Agreement law, including the temperature thresholds. So that's one area where we expect that we'll be using attribution science there. One thing I should also note is that it's not just about coal in Papua New Guinea. PNG actually has the third largest rainforest in the world after the Amazon and the Congo Basin. And so when mining happens there, it also actually takes a large chunk out of one of the world's most important carbon sinks, and also one of the world's most important biodiversity hotspots. Another case that we've been working on, and this will come back to what Rupert was saying in terms of the importance of where we look at how to develop attribution science. So this case is called the youth verdict case, and it relies on new legislation that was passed in Queensland, which requires all decision makers to take into account human rights issues. And so we're going after we're asking the Land Court to have a look at the human rights impacts of one of the mega mines in the Galilee Basin on young people, as well as Aboriginal and Torres Strait Islanders. And you can see actually the cultural rights very much merge in with environmental rights. And so the physical impacts on the environment end up actually being cultural impacts as well. And so that's where we can bring in this particular right and to line it up with attribution issues. So I just wanted to make some small reflections on what I would say call decolonizing climate litigation. And so the interesting thing about the Pacific is that when you have a look at it with all of the states, it looks like it's small, but we don't think about it in those terms. We actually think about the ocean being what connects us. And so the important thing that for us is that even though we're small and we have small scale impacts, climate change is going to really affect our life worlds. It's going to affect our stories. All our stories are related to to birds, to fishes, to whales, to sharks, to all things that are going to be affected by climate change. And one of the things that we are looking for from attribution scientists is to help us in relation to making those particular links between those small impacts, which may seem small, but actually are the foundations of our identities and foundations of our worlds. One of the ways that I think attribution scientists can do that is to actually look at Indigenous methodologies themselves. Indigenous peoples have spent thousands of years observing, dwelling within, relating to the environment, and know the environment in an empirical sense. And so Dr. Anne Polina here, who's an Aboriginal woman, will say Indigenous peoples are the first scientists. And I would say we're the first environmental lawyers, because our customary law and our first law embeds our knowledge of the environment. So there's lots of observational data. In the youth verdict case, for example, our Aboriginal and Torres Strait Islander experts are telling us what changes they're seeing, when those changes happened. And so we're looking, the task is for attribution scientists to actually work with Indigenous peoples. The reason why I've got this up in terms of decolonizing the research is one, to respect that Indigenous peoples have a science, and that's the observation, that's the impacts that they're seeing, and the approaches that scientists can make when they come, in terms of recognizing the knowledges that are in the area, and to help us to actually deal with some of these issues, because the impacts are not just in terms of our cultural worlds, but also biodiversity. So 80% of the world's biodiversity is on Indigenous lands. And so we would like to see attribution deal with the question of biodiversity as well. And I think I'm going to go over time. I did have some more statements, but I think I'll leave it there. Thanks.
Thank you, Fleur, particularly for that call at the end to decolonize the research agenda for attribution science and a focus on sort of small impacts that are foundational to the identities of the people that you work with and that you represent, and decolonizing also the methods of knowledge production. So both sort of excellent points and eloquently made. Thank you for that. Our final speaker on the panel is Dennis von Berkel, who sort of spearheaded the first and most successful case in the Dutch courts, the Urgenda case, which is now, of course, famous. He is legal counsel to the Urgenda Foundation in the Netherlands, and is the director of the Climate Litigation Network, which supports litigation around the world that seeks to increase national climate mitigation ambitions, so to address the adequacy and ambition gap that I referred to in my remarks earlier. Dennis will explain how scientific evidence has been used in lawsuits seeking to protect human rights through compelling defendants to reduce their greenhouse gas emissions. And he will, of course, draw on his experience as legal counsel for Urgenda Foundation. Dennis?
Thank you, Lavanya. And thank you for organizing, thank you Oxford University for organizing this great event. It's because of huge importance, especially because one of the crucial things in climate litigation and the way that, or the route that climate litigation is going to have is actually interaction between the scientists and the lawyers. That's going to be the most crucial thing, I believe. But let me say a couple of things about the Urgenda case and cases that followed. In those cases, when we filed the case in 2013, climate science as such was, in the views of many legal scholars, seen as something that was still too diffuse and not certain enough to be able to use in the courts. And I think one of the things that our case and cases that followed established is that there is actually a lot of certainty, at least as much certainty that you would need for a lawyer in order to create responsibility on the side of a state or a corporation. And that was primarily with regards to the types of cases that we were, or the type of case that we filed, which was a case with regards to ambition into the future. So those cases primarily look at probable or likely effects in the future if we act in a certain manner. So the basic question that these cases asked was, what if we keep emitting on this trajectory, or what if we lower emissions? What is the difference in probability of certain impacts happening into the future? And with regards to the standard that was then applied by the courts, this was also, the standard was a standard of a risk of harm. So we didn't exactly needed to prove precisely what the harm was going to be, as long as we could prove that there was a certain risk of harm occurring. Now, something that Professor Rajamani also mentioned in the beginning, and which is very important to realize with this type of litigation, is that it is basically plugging holes into a global accountability system which is imperfect. But the plug itself is also an imperfect tool, and the imperfectness of that tool very much defines and determines why we need certain science which you would otherwise not need. And that is because, by and large, something that is important to realize is that these types of cases, these ambition types of cases, they do not directly enforce obligations under an international legal structure. They do not directly enforce the Paris Agreement, for instance. What they do enforce are more general obligations under the domestic legal system, primarily human rights obligations. And what is specific about these human rights obligations is that at least thus far, these human rights obligations have by and large been interpreted as obligations of the state towards its own inhabitants. And that also means the type of evidence that you will need in these ambition types of cases is with regards to the impacts of the own inhabitants on the own territory, and also by and large the inhabitants that are already there, the people that are born. There are some cases, and there have been some judgments with regards to the rights of future generations, the unborn, but by and large the legal system is only able to look at what the rights are and the impacts are of the people that have been born within the own territory. So that gives you a much narrower scope than the global overall impacts, and that also requires you to be able, as a plaintiff and as a litigator, to define much more specifically what the impacts within a country are rather than an entire region, and perhaps even what the impacts are with regards to a province or even a city within that country. So although the level of how important it is to go to this more granular level, that very much determines, it's very much determined often by legal systems and different standards in legal systems. So for instance, in the Dutch case, it was accepted that that the fact that the entire population was basically at risk did not mean that there was no standing for individuals. And that is also what is being determined in the German constitutional case, to which Professor Rajamani referred, but also very recently, even more recently, in a case before the Belgian court, 52,000 plaintiffs were regarded to have standing in that case with regards to impacts. Where does it become more complicated in the context of litigation is when the asks of plaintiffs are not with regards to some risks in the future that are more general and that are in relation to an obligation to reduce emissions to prevent those risks, but when the claims are with regards to adaptation measures or actually claims for damage. And those are also the cases that are the main focus of the paper that was presented and is sort of the main reason for having this event. There we see that this link between what is actually a climate impact and what is actually the damage and what do we need to do to prevent that damage with regards to adaptation becomes more and more important. But also connected to that, as this litigation develops and as long and as we grow into the direction of the recognition that more and more of these impacts will become inevitable, it will also become more and more important for climate scientists to identify not only between the risks that are happening in the future and the adaptation that is needed, but also to combine the two. Because with regards to the mitigation and ambition cases thus far, we've only basically looked at what can we prevent, but it's becoming more and more clear that some of the impacts will no longer be able to prevent, and that we need a more integrated approach with regards to what can we prevent, and what can't we prevent, and that the litigation will go into a direction of not only asking for mitigation efforts, but simultaneously actually asking for adaptation measures as the only combination of means that can protect human rights. Another very important area that will of these cases is then if we determine that there is a duty on the side of the state to reduce emissions and even to take adaptation measures, the question is how much should a country reduce? And this is one of the key, most difficult questions that have been posed before courts with regards to some of these mitigation cases. And this is really this fairness and equity question that Professor Rajamani also referred to. And I think it's important here also to mention that she is, in fact, also the main author of a very important paper that is about to come out in this respect, which looks at the range of equity interpretations that have been put forward by the scientific community, and then assesses these equity methodologies with regards to how much countries should be doing, and assesses them on the basis of international environmental law, giving a legal interpretation of what the fairness requirements on a state are. And it's important that this discussion within the scientific community continues, not just with regards to refining the scientific and legal methodology, but also that there is basically advocacy on the fact that this science exists and that it is important. Because the more that this is discussed, the more that there is also a recognition of the fact that we basically only have one carbon budget that can only be divided in so many different ways. And where we see the importance of this is, for instance, in the German constitutional case. That case was not based on a specific scientific report, but it was based on an advice by an advisory council on environmental issues to an advice to the government. And that's in many of the cases we see that these sort of advisory bodies, when they describe what the state of the knowledge on a particular issue is, that gets a higher level of recognition by the courts than just one individual paper. And what we need to get these advisory bodies also to actually adopt these types of methodologies that are so important is a lot of advocacy basically on the importance of these methodologies also on the side of science. And I will close off with a number of areas that I think will need to be developed going forward, and some of those elements actually flow from the results of this paper that I just referred to, that is which Professor Rajamani is the main author, and that is the conclusion of that paper is that if we look to these different effort sharing methodologies and we look at what is necessary with regards to a fair share of especially the developed countries, we see that these developed countries would by and large need to reduce their emissions to zero by 2030. And this raises a whole range of other legal questions which require scientific input. The first question is, will countries be able to reduce to zero emissions by 2030? So we will need scientists to explain to us how this might be possible with less conventional means. What we also need more information on is if there is a responsibility on the side of the state to reach zero emissions. What we're talking about is net zero emissions. So we'll also need more information with regards to what is actually the capacity of the country itself to have negative emissions on its own territory. And following from that, what are the consequences of basically overblowing that fair share? How can a country compensate if it does not reach net zero emissions in 2030? How can it compensate for those emissions on its own territory? But also, how might it compensate for those emissions on other territories? Thus far, the only real engagement with this topic has been in the context of a potential global carbon market, which we still do not have, and the feasibility of that global carbon market is not, does not seem very real, or at least in the short term. So scientists will also need to come up with credible ways and credible examples and models and standards that can be applied by courts, because courts will not be able, and they are very unlikely to develop these types of standards themselves. This is one of the things that we see in the cases thus far, is that courts are willing to adopt certain standards developed by science, but they're very unlikely to create those standards themselves. And lastly, one of the territories that I do think that needs more engagement also from the scientific community is what are we going to do about the responsibility with regards to aviation and shipping. One of the huge gaps and blind spots of the current climate litigation efforts is that we perceive the global carbon budget, we look at the global carbon budget and we divide it up amongst countries, but we ignore the emissions of shipping and aviation because this is simply not dealt with in the context of the Paris Agreement. But this national climate litigation is not a direct enforcement, as I mentioned, of the Paris Agreement, and we only have one carbon budget. So these emissions are going to contribute as much to climate change as any other emission, and we need to get to grips with what the legal responsibilities of countries would be outside of the Paris Agreement in the context of these human rights frameworks. And what are then the responsibilities of countries with regards to, for instance, the fuel that is tanked on an airport or a port. So we need more integration and answers and standards of how we might deal with that sort of responsibilities. And those discussions from science are then very likely to also inform conversations and discussions in courts. And I would like to leave it to that, and again thank the organizers for setting up this incredibly important event, and also contributing with massively important papers to the actual discussions that we're having in courts today and in the future.
Thank you, Dennis, for identifying for us sort of several important trends and actually even gaps in international and regional and national climate litigation, and also identifying a very clear set of questions for the research community to address. So those of you in the audience that are sort of looking to do PhDs, well, Dennis has identified sort of important questions for you to address. And it's usually the whole first year of a DPhil that you need to spend trying to identify the question. So Dennis has done that for you. So thank you, Dennis, for that. Your contributions both to the practitioner sort of community and to climate litigation, but also to the scholarly work that we're all engaged in. So we have maybe 8 or 10 minutes for questions, because I do want to leave a few minutes at the end for Tom Wetzer to introduce the Sustainable Law Program to you all. I am going to exercise my discretion as chair and just direct questions at the panelists. And this is going to be fairly idiosyncratic because there are several questions that have come in, but I'm just going to choose ones that I think our panelists can quickly address. So to Rupert, there are several questions on attribution, but one question that I thought might be interesting for you to address is by Christina Thomas. Could attribution science also be used for projections of attributions of future weather events, example to the coal mine that Australia wants to build on the island, and be used in court to help cases prevent new coal mines by projecting the consequences and future losses?
Thanks very much for the question. Whether it will be explicitly termed attribution science is a different issue, but the short answer is yes. The kinds of methods that we're talking about could be used to understand changes in future risks, both from emissions as a whole, but also understanding how smaller contributions to emissions, so for instance those linked only to individual fossil fuel projects, how those are likely to affect future risks as well. And so as a short answer, yes. And there have been a few papers which have looked at the contributions of individual companies or countries' emission commitments to, for instance, future changes in sea level rise. And there's a growing body of research also on future risks of extreme weather too.
Thank you, Rupert. To Dennis, a question from Daniel Schaaf. How can judgments in one country influence cases in other countries? And as director of the Climate Litigation Network, I think you'd be able to sort of answer this question with extensive sort of references to national cases.
Well, yes, but I think there's also a very short answer to that. What we actually see in all of these cases, remarkably, is that almost all of these judgments refer to cases in other countries. So the Rocky Hill judgment in Australia referred to a whole range of climate litigation around the world. The German constitutional case, when referring to the fact that every country has its own individual responsibility to do its fair share, directly referred to the Supreme Court in the Netherlands. So all of these cases, the judges themselves are really looking across the borders, looking for inspiration, and that's also one of the things that is important for litigators to be aware of, to actively provide these judges with these different cases around the world, and to help them and inspire them that these questions that they are confronted with, although they have their own legal system, many of the questions, like 80% of the questions they have to grapple with, are by and large very similar across all these different jurisdictions. So we do see that courts are getting inspired and are really learning from each other very actively already.
Thank you, Dennis. I wonder, Flo, if you could add your sort of comments on this question as well in relation to the cases that you've litigated in the Australian courts.
Sorry, can you just repeat the question?
The extent to which judgments from other jurisdictions are relevant and useful in the cases that you litigate.
Completely useful, because one of the things that we've been having to deal with is the way that we frame the future losses or frame the case. And I think that once, for example, Rocky Hill, I think did a lot for us in relation to causation and dealt with a lot of arguments that a lot of carbon majors and countries were putting up in terms of saying that it's substitutable, and also in relation to this one project, it doesn't mean much, it's only a small impact. And I think Justice Preston actually did a lot in relation to helping us with that reasoning process. And I would say the same with Shell. The Shell case and the Ugenda case has been really important for us and at looking on how we frame the human rights issues. So I think it's extremely important. Every climate litigator reads every case that comes out to see and to mine it and to see the reasoning and how we can use it for our cases.
Thank you, Flo. There's also a question for me from Freddie, which I'm sort of going to take the opportunity to answer. Could this research help move the recognition, if not compensation, of loss and damage forward in international climate policy? So great question, Freddie. I think this research is tremendously impactful, but in terms of moving climate negotiations forward, it's not the lack of scientific evidence that is at the root of the lack of movement on loss and damage in international climate negotiations. It is a deeply political, as you know, and contentious issue. So increased evidence and substantiated evidence is not necessarily going to take that issue forward in the negotiations, certainly not in terms of any legal sort of changes in the international negotiations. But in terms of policy, in terms of acknowledgement, in terms of solidarity, there's certainly going to be much more strengthening of that in the face of the sort of increasingly well-supported evidence that's being produced of the sort of science that you're sort of spearheading. So absolutely.
Lavanya, may I add something very briefly?
Yes,
to that?
Dennis.
And that's on the basis of our recent experience here in the Netherlands, following the Shell case, in which the Dutch court concluded that there is actually a human rights obligation on a corporate to reduce its emissions, basically in line with the IPCC advice. And this case really shows that there's a very strong link between corporate accountability and government response, and government taking responsibility for the impacts. Because what we've seen in the Netherlands now is that following also this case against Shell, where there's now an obligation on Shell to reduce its emissions, The government also stepped up with regards to its policies on greening the entire Dutch heavy industry, of which Shell is an important part. So just litigating against corporations very much has, albeit an indirect effect, it can have a very big effect on the way that governments are going to deal with loss and damage, because once they recognize that there is this corporate responsibility possible under legal systems, they're basically afraid of the 1,000 lawsuits that might follow, and it's very likely that they'll want to step in, prevent those 1,000 lawsuits, and actually start organizing for this loss and damage themselves.
Thank you, Dennis. That's also an excellent point. So there are several very interesting questions and more popping up by the minute. I'm afraid we don't have time to have the panelists address all those questions, but I will direct the questions at the panelists, and maybe you can continue this conversation over email or other exchanges. I'm sure the panelists will be happy to respond to your questions, offline, as it were. We have 5 minutes now left in this session, and I'm going to turn to Tom Wetzel, who's the director of the Sustainable Law Program, to introduce you to this amazing new program that we have in Oxford that he's sort of spearheading, and which has produced this remarkable paper, and which produced many such remarkable papers and events going forward. Tom?
Thank you, Lavanya. I hope everyone can hear me. The screen is a bit slow to load. Thank you, Lavanya, and thanks to all the panelists for their contributions, as well as everyone who attends this event for their interest. My contribution will be very brief, but in short, I want to introduce you to the Oxford Sustainable Law Program, which put together this event, which is hosting the work on attribution science and the law, and critically, which is likely to do much more along these lines going forward. So the Oxford Sustainable Law Program is a recently established and rapidly growing program at the University of Oxford, focused on research, education, and engagement in the broad area of law and sustainability. It's a joint initiative by the university's Faculty of Law, by the Smith School for Enterprise and the Environment, and the Environmental Change Institute, and being in that place, between disciplines, the program is really bringing together scholars from a wide range of legal fields, but also non-legal disciplines from across the university and beyond. And that interaction between lawyers and scientists, between academics and practitioners, is central to what we do. And I think we've seen today how important that can be, not only, frankly, in the area of science and the law, but across a range of legal fields more broadly. The aim that we have is that through rigorous research and through innovative education, we aim to achieve impact in the law and sustainability space. So our tagline is that we leverage the law to catalyze the sustainability transition. Now, currently we focus our research on 4 themes. The first is around science and the law. That's really what this event has all been about. We also do work on what we call systemic lawyering. So that is meant to inform how lawyers think about their outcomes, the outcomes of their work in systemic terms, because after all, most sustainability challenges at the moment are so huge that it's not enough for one actor to change their ways, but it requires a change in the way in which our economies and our societies function. And so that systemic perspective is critical. We also work on climate risk governance in the private sector and in the public sector, focusing on issues like corporate governance, like climate risk disclosures, and like the impact of corporate law on the way in which companies engage with these sustainability challenges. And finally, we work on the interface between law and the net zero transition. So we call this net zero compliant legal action. And this includes work on the kind of legislation and contracting that is needed to accelerate the net zero transition, and critically, to make that net zero transition real and credible, and not one that is primarily greenwash or by actors ducking their responsibilities. Now, of course, the scope of the research is likely to expand as our team grows. We're a very new organization, very new program. We're only around for less than a year. So please stay tuned and reach out if you think there are other areas that we should work on. Now, in addition to producing research, we also work to educate the leaders of today and tomorrow through education at Oxford, but also through education that we provide around the world. And we engage actively with governments, the private sector, NGOs, and beyond to make sure that our research is actionable and translated into impact. Now, why are we taking a moment to tell you all this? Because after all, you could also just click on the green button right below on the screen, go straight to our website and read about what we do in your own time. Well, I'm telling you for 3 reasons. The first is that we want you to know that we exist and what we're doing, so that in your work, you can build on the work that we've been doing and engage with it. The second reason is we want you to help shape and contribute to what we do. We work with people and organizations around the world on major sustainability challenges and on the role of the law in addressing them. And if you're interested in working with us as well, please do let us know. And finally, I'm telling you because we are growing our team. We're hiring postdocs, we're taking on PhD students. And so if you're interested in joining us, please have a look at our website and keep an eye on our Twitter feed. Now, just to conclude, the sustainability challenges are, of course, urgent and complex, and we will need, as we have seen today, clever and bold use of the law, working in tandem with insights from other disciplines to make the changes that we need at the pace that we need to see. So I want to thank all the panelists for today that were here today for sharing those perspectives. It's been a fascinating discussion, and we're looking forward to working on all the issues that were raised as being critical, and we hope you will join us as a community in doing that. So thanks again for all attendees, and in particular to all the panelists who made this event such an interesting one. Thank you all.
Thank you.